Federal Circuit affirms. Invalidation of catheter patent claims. The Federal Circuit has affirmed the Patent Trial and Appeal Board's, PTAB or Board, invalidation of Shockwave's angioplasty balloon catheter claims on the basis of obviousness. The case is Shockwave Medical Inc. vs. Cardiovascular Systems Inc. As the court explained, Shockwave owns the 371 patent entitled Shockwave Balloon Catheter System, which is directed to the treatment of atherosclerosis through intravascular lithotripsy, IVL. The court also explained that lithotripsy is a well-known technique used in the treatment of kidney stones that involves sending shock waves, a form of high-intensity sonic wave, directly toward kidney stones. The shock waves break up larger stones into smaller stones, allowing them to pass through the urinary system. The 371 patent applies this technique to breaking up calcified plaque deposits in the context of treating atherosclerosis. The claimed device uses a typical over-the-wire angioplasty balloon catheter and adds electrodes and a pulse generator. Cardiovascular Systems, Inc., CSI, filed an IPR petition challenging all 17 claims of the 371 patent as obvious over various prior art combinations. As the court explained, CSI argued that it would have been obvious to an ordinarily skilled artisan to modify Levy with the well-known angioplasty balloon catheter disclosed by the applicant admitted prior art, AAPA. Its proffered prior art combinations, which are the subject of the appeal and cross-appeal, involved Levy as modified by AAPA in combination with other prior art references. As the court explained, AAPA is art referenced in a patent application that is admitted by the applicant to be prior art. We recently approved the role of AAPA as evidence of general background knowledge of an ordinarily skilled artisan. However, said the court, AAPA cannot be the basis of a ground in an IPR petition. Because the board hadn't addressed the issue whether the AAPA formed the basis of the petition, the court remanded to allow the board to address this issue. On remand, the board held that AAPA does not form the basis of a ground in violation of Section 311(b) if the ground relies in the AAPA in combination with permissible prior art patents or printed publications. Based on this interpretation, the board found that the ground relied upon by the petitioner was compliant with Section 311(b). Under 35 U.S.C. Section 311(b), a petitioner in an inter partes review may request to cancel as unpatentable one or more claims of a patent only on a ground that could be raised under Section 102 or 103, and only on the basis of prior art consisting of patents or printed publications. On a second appeal, the court reversed, since the IPR petitioner had expressly labeled the AAPA as part of its basis for its obviousness ground. In 2023, the PTAB issued its final decision on rehearing, relying on AAPA only as evidence of the background knowledge in the art as to typical over-the-wire balloon catheters, and again determining that claims 1 to 4 and 6 to 17 had been shown to be unpatentable as obvious, but that Claim 5 had not. The parties cross-appealed. The Federal Circuit noted that this case was different from a previous case in which the petitioner expressly labeled AAPA as the basis for its challenge. Here, said the court, CSI used AAPA only to show, as the 371 patent itself acknowledged, that the over-the-wire angioplasty balloon catheter was well known in the prior art, and that this general background knowledge satisfied the 371 patent's claim limitations relating to an over-the-wire configuration. Said the court, we have not previously decided whether AAPA improperly forms the basis for a petition when it is used to show that a claim limitation, characterized by the patent as not disclosed in the prior art, would have been obvious over the prior art. That is not the case here, where CSI properly relied on general background knowledge to supply missing claim limitations, which Shockwave does not argue were novel to the invention, and used AAPA as evidence of that general background knowledge. The IPR petition did not violate Section 311(b). The court subsequently affirmed the board's determinations as to claims 1-4 and 6-17 in Shockwave's direct appeal. and reversed the board's determination as to Claim 5 in CSI's cross-appeal. Need expert advice with your intellectual property portfolio? Call us for an appointment at 206-533-3854 or visit our website at www.aeonlaw.com. Aeon Law, Unleashing Genius.